Hi, my name is Assad Hafiz. I'm an immigration attorney, and I am producing another video here for immigration case law updates for your benefit so that you can see how the immigration courts are deciding immigration cases and applying immigration concepts from mid-August 2018 through September, and now we're already in mid-October 2018. With no further ado, let's get into it. Ninth Circuit, U.S. versus Fomichev. It was decided August 8, 2018, concerning a Russian individual accusing him of false statements on immigration documents. This can be a major problem when submitting immigration filings. Well, basically, they submitted surreptitious recordings from his own wife to bring these type of charges against him. Secret conversations between husband and wife. Well, basically, although federal agents requested the wife to do this, this evidence was inadmissible under the marital communications privilege. The Ninth Circuit agreed on appeal. Previous court made an erroneous finding regarding marital communications privilege, so it was remanded. This is basically more of an evidence type case, highlights a tool that immigration attorneys can use, which is called a motion to suppress. So this was a good case where you can use a motion to suppress when there's illegal, wrongfully obtained evidence being used to deport or remove a client. Next case is out of the Ninth Circuit, Rodriguez versus Schwartz. It's decided August 7, 2018. This is actually an example of several cases I'll be sharing with you where it may appear to be more of an immigration situation, but it's actually a civil case. U.S. Border Patrol agent actually shot and killed a teenage Mexican citizen walking down the street. The agent was claiming qualified immunity. The agent moves to dismiss the complaint that was filed. Mother of the deceased child was suing for relief. And the Ninth Circuit held, under these facts, the agent was not immune from a suit. The boy's mother had a cause of action against the agent for money damages. You can have civil cases produced from these immigration-related situations. Next case is Aker versus United States. This was decided on August 9, 2018. This is, again, something very similar. This involves the Federal Tort Claims Act, the FTCA. Lawsuits are aimed at federal officers, federal agencies. The Ninth Circuit, in this case, allowed the suit to proceed against officials that wrongfully removed or deported an alien. That happens every so often. Someone is wrongfully deported or removed. Well, federal officers can be subject to liability under the FTCA, the Federal Tort Claims Act. Next case is out of the Second Circuit, Jane versus Sessions. This is August 13, 2018. Basically, this individual was convicted of drug charges. This was a Panamanian man. He had U.S. citizenship. Therefore, he was not removable because he's a citizen. Person might not know it at the time they're in removal proceedings. They may be a citizen. They might be a U.S. citizen. If they can establish that in court, they may have a criminal offense. They might even have drug charges, but they are not removable because they are a U.S. citizen. Next case is out of the Ninth Circuit, Askins versus U.S. Department of Homeland Security. This was decided August 14, 2018. Two individuals stated a First Amendment claim, Customs Border Patrol, because they were taking pictures and basically the agents came in and confiscated their pictures. It's not exactly immigration, but it's immigration related and it creates civil liability. In this case, this was constitutional First Amendment type case. Ninth Circuit held that these individuals properly pleaded First Amendment claims and reversed the previous court's dismissal of their pleadings. It's wrong for the Border Patrol agents to confiscate these pictures. That was a deprivation of First Amendment rights. U.S. Ninth Circuit, Lanuza versus Love. This is decided August 14, 2018. This is another civil case coming out of an immigration-related case. It reversed the dismissal of a green card holder's Bivens action, a Bivens claim against government immigration attorney. That attorney submitted forged documents at immigration proceedings. The attorney who was defending the alien did good work and discovered this forgery. Because of the forged documents, the applicant was denied specific reliefs in the immigration court. And the Ninth Circuit allowed a Bivens claim to proceed against this federal officer and discussed in detail the limitations of these sort of cases against federal officers. Okay, out of the First Circuit, this is Sihotang versus Sessions. This was decided August 15, 2018. The First Circuit here granted a petition for review of the denial of a motion to reopen removal proceedings. It agreed with the alien that there was a material change in country conditions and a finding of prima facie eligibility for asylum. So country conditions can change. This individual is from Indonesia, evangelical Christian, and argued upon return to his home country he would be persecuted based on his religious beliefs. That may have not been the case earlier, but country conditions had changed over time. So this individual reopened their case to show that because of the change of conditions, now he has a valid asylum claim. This next case is from the Supreme Court of California, Bianca M. versus Superior Court, Gladys M. This was decided on August 16, 2018. An immigrant child's father from Honduras did not have to be joined as a party in her parentage action seeking special immigrant juvenile findings. It was a 10-year-old entered the U.S. without authorization and sought to be reunited with her U.S. resident mother. Argued it should not matter whether the court has personal jurisdiction over the father back home and whether she had filed a family court action with an immigration-related motivation. Agreeing with her, the applicant, the California Supreme Court reversed the Court of Appeal, which had upheld the denial of her request. So this case is really big because it clarifies how you can do special immigrant juvenile status in California. Basically, this is one of those rare situations where you can go into a California family courthouse and obtain immigration relief. You've gone to Sacramento, Power Inn Road Family Courthouse to obtain special immigrant juvenile findings, which support a minor getting the protection that you can get from special immigrant juvenile findings. You have to go to a family court to get this immigration relief. The Supreme Court of California specifically held it's not essential that there be a pending immigration matter or family case to grant this relief. This next case is under the Ninth Circuit. It's called Quiros Prada versus Sessions. It was decided August 29, 2018. The Ninth Circuit concluded that a longtime green card holder was eligible for asylum and withholding of removal. It remanded it back to the BIA, reconsidering of his Convention Against Torture claim. This individual was from El Salvador, and he was citing violence that he suffered at the hands of a paramilitary group. So this is one of those cases where it's from Central America. These cases can be a bit difficult. Practitioners don't always raise all the type of arguments that can be raised. It's very important because a lot of these type of cases, the difficulty is a lot of them are dismissed as mere general criminality, generalized crime, generalized violence. At one time, recently, there were cases that encouraged judges to grant asylum or Convention Against Torture upon a finding of mere victim of domestic violence. Well, that alone is not enough. You need to be part of a protected category, a protected group of some kind. You need to be targeted for your traits or characteristics, for your membership in certain associations, groups, physical appearances. Could be that you have certain political beliefs, certain religious beliefs, a certain race or ethnic group. You need to be targeted because of those traits and characteristics, either by the government or a group that is under the control or beyond the government's control. It could be under the blessings of the government that you're being persecuted. And so a lot of these type of cases run into trouble. They get dismissed as mere criminality. They get dismissed as personal vendettas. This is where a lot of gang and cartel type cases run into trouble. Also domestic violence cases, being a victim of a specific crime or a victim of domestic violence is not enough. So a good practitioner in immigration law has to create as many arguments as possible to win an asylum or Convention Against Torture claim. Convention Against Torture is a bit different from asylum because you are arguing that you suffer a more than likely, or the risk is more likely than not you will suffer torture upon return at the hands of the government or by acquiescence of the government to other groups or forces or individuals. You don't have to be a member of a protected category under Convention Against Torture. Also from the Ninth Circuit, U.S. versus Garcia Lopez. This was decided September 7, 2018. The gentleman argued he should be permitted to withdraw a guilty plea that he made because of the Supreme Court's decision in Sessions versus De Maya, 2018. It undermined the basis for his indictment, and the Ninth Circuit was persuaded, vacated, and remanded this decision with instructions to permit him to withdraw the guilty plea. So basically, this Sessions versus De Maya decision by the U.S. Supreme Court has been very helpful, and Ninth Circuit here dismissed the gentleman's previous case. He was allowed to withdraw his guilty plea to the charge of illegally re-entering the United States because he did not receive the proper warnings and notices under the Ninth Circuit, so he could withdraw his guilty plea. Okay, under the Second Circuit, we have Khalid versus Sessions. This is a terrorism-related case. It was decided September 13, 2018, and he argued he couldn't be removed because he was a U.S. citizen through his recently naturalized father. Agreeing, the Second Circuit held that DHS must terminate removal proceedings against him. So this is another situation like before, the other case that I mentioned. If you can show that you have acquired citizenship, you're out. It doesn't matter what you're being accused or charged of. This man was being charged of terrorism charges, but he could file his motion to terminate the removal proceedings because he established he's a U.S. citizen. Next one from the Ninth Circuit here is Sanchez versus Sessions. It granted petition for review of a removal decision. This was for a Mexican individual. He was seized only because of his Latino appearance. Therefore, the government's evidence was improperly used against him. Finding merit in the arguments, the Ninth Circuit remanded for further proceedings with instructions that the agency may consider whether the violation was so egregious to warrant terminating removal proceedings without prejudice. So this was decided September 19, 2018. And this connects again with that evidence concept. You look like you're not a citizen. Well, that's not a legal basis to stop someone, and the evidence that you acquire thereafter is fruit of the poisonous tree. Everything you acquire after that is arguably illegally obtained evidence, improperly obtained evidence. So this is, again, more of an evidence-type case, and you can file a motion to suppress. And in this case, the Ninth Circuit was willing to entertain a motion to terminate removal proceedings. And that's it for now. That's all the way up through September. My name is Asad Hafiz, an immigration attorney, and I will continue this series of giving you more immigration case law updates for your benefit and education. Thank you, and bye for now.